Hello everyone, this is Shiv Prem, legal intern at LEXIS and Company, and currently pursuing BLLB honors from Central University of South Ghana. In this video, I will be dealing with the second part of the theories of attempt. In the first part, I had gone through the introduction part, and then I had gone through the attempt, definition of attempt, what is an attempt to commit a crime, essentials of attempt, and innocate crime, and other parts. In this video, I will be dealing with the test for determining whether an act amounts to a mere preparation or an attempt to commit an offense. In spite of the fact that the above cases give us the understanding with the respect to what is an attempt and what is not. It might change from case to case. It relies on current realities and conditions of the case and the kind of offense being submitted. So the judgment had set down not many standards or otherwise called tried through the recognition of the cases for deciding with respect to what technique for approach can be applied relying on the conditions and realities which occurred, all things considered. The first one was the proximity rule. Proximity in the relation to time and action or to intention. The proximity test analyzed how much the litigant was near finishing that offense. Estimated contrast is the separation between the groundwork of the offense and effectively frustration of that offense. On the account of the Commonwealth versus Hamel, it was held that the vicinity rule found left to be done, not what has just been done, that is examined. In the case of R versus Taylor, the accused who had the aim and made readiness to set the bundle on fire took a matchstick and lit it. However, then set it aside for the explanation of being viewed. At that point, when the denounced was gotten for his demonstration, he claimed that he was simply planning for such a demonstration, however didn't attempt, as the matchstick was put off and it was still in his control to fire it. The court dismissed the dispute and held that the demonstration of terminating the matchstick was the plain demonstration which was towards the achievement of the wrongdoing and was viewed as an attempt to illegal configuration. The simple truth is that the matchstick was put off because the dread of being viewed was superfluous. Now, let us see the doctrine of locus poenitei. It manages those cases wherein an individual made readiness to carry out a wrongdoing, however, alters his perspective towards the end, consequently pulling out at the last moment. Such deliberate withdrawal before the commission or attempt to carry out the demonstration will be named as a simple groundwork for the commission of the wrongdoing and no lawful obligation will be forced. In the case of Malikat Singh versus the state of Punjab, the accused were a transporter and the cleaners who were to hold almost an obstruction checkpost in Punjab, which was secretly any miles from the between a state fringe of Punjab and Delhi. They were accused of conveying 75 packs of paddy illicitly being pirated alongside to later composed by the consignors in Punjab to the recipient in Delhi. The accused were charged for the act, that is the attempt to pirate paddy infringing upon the Punjab Paddy Export Control Order 1959. The High Court held that it is a simple arrangement, however, not a demonstration of attempt, as the conveying of paddy in a truck was such a demonstration which had plentiful extension for the charge to alter their perspective or to be hindered. Now the third one was ambiguity test. This test is a blend of the over two standards. The test requires the unequivocal goal through the demonstration done, which is viewed as satisfying past sensible uncertainty that the end is toward the proposed wrongdoing. In the case of state versus Parsamal, the denounced got a request to purchase diesel of good quality, and they requested that the client come to the following day. That night, the denizens were seen blending the diesel in with the lamp fuel and were accused of the offense by the following day. The denunciation guaranteed that what they did was simple planning. At that point, the court saw that when they realized that the client planned to come the following day and in the felicitation, the charge attempted to add diesel and lamp oil at night itself. So they were not gotten or seen by the client. Although they did as such to act in a manner to swindle the diesel was of acceptable quality. Further, there were some exceptions. The penal law punishes attempts only, but in certain cases, preparation to commit a certain offence is also punishable, like preparation made for waging war against the government of India, preparation made for the committing depredation on territories of any power in alliance or at the peace of the government of India, making or selling of being possession of instruments or counterfeiting coins or government stamps, possessing counterfeit coins, government stamps, false weight or measures, preparations made for committing dacoity. Now, real commission of the offence is not imperative to demonstrate anybody liable. Anybody can likewise be blameworthy of simple commission or attempt to commit an offence under Section 511 of the IPC. There are three bases for the attempt of the offence. The underlying stage is to set up an appropriate outlook for the offence. Furthermore, it continues a stage forward toward the commission of that offence. In conclusion, neglect to submit that planned offence. Exceptions to murder somebody by a vacant weapon is not wrongdoing. However, it is fulfilling all the fundamentals of an attempt of wrongdoing. Along these lines, this is the culpable under Section 511 of the IPC. There are few standards for deciding if the act adds up to a simple arrangement or an attempt to submit an offence. That's all for now. Let us meet in the next session with a new topic. Thank you.